Number 50. Justice James Wakiaga. I find you guilty of failing in law and fact by not recognizing that private prosecution is oxymoronic in that all justice is public and the private prosecution in a public institution and open to the public. Number 51. Justice James Wakiaga. I find you guilty in failing in law and fact by quoting Erore Greenveld versus AG and two others, petition number 3 of 2013, out of context. 52. Justice James Wakiaga. I find you guilty of failing in law and fact by giving a ruling devoid of law, reason, logic, or correct case law. Number 53. Justice James Wakiaga. I find you guilty in failing in law and fact by not giving a ruling that furthers the cause of justice. Number 54. Justice James Wakiaga. I find you guilty of failing in law and fact by making legal substance out of a quip by the applicant. Number 55. Justice James Wakiaga. I find you guilty in failing in law and fact by not recognizing that in a suspect criminal incident in which the motive suspect is a member of the police service, the matter teems with extrajudicial and prejudicial influence. Number 56. Justice James Wakiaga. I find you guilty in failing in law and fact by not recognizing that the circumstances under which an average person might want to institute private prosecutions. Justice James Wakiaga. I find you guilty in failing in law and fact by not recognizing the real stakeholders in criminal justice is the criminal, the victim, and the public that owns justice, and everybody else is an employee. Number 58. Justice James Wakiaga. I find you guilty of failing in law and fact by not recognizing that there is no private institution or proceedings in Kenya. Number 59. Justice James Wakiaga. I find you guilty in failing in law and fact by not recognizing that the state did not ensure access to justice for the complainant in conflict with the Article 48 of the Constitution of Kenya. Number 60. Justice James Wakiaga. I find you guilty of failing in law and fact by not recognizing that state functionaries denied the applicant the right granted under Article 51 of the Constitution of Kenya. 61. Justice James Wakiaga. I find you guilty of failing in law and fact by not recognizing that there is a legal lacuna between the police service and the office of the Director of Public Prosecutions. Number 62. Justice James Wakiaga. I find you guilty of failing in law and fact by not recognizing that Article 25A, B, and C of the Constitution of Kenya does not just refer to suspects, but to the victims as well. Justice James Wakiaga, I find you guilty of failing in law, fact, and honor by introducing sophistry in proclaiming justice. Finally, Justice James Wakiaga, I find you guilty of participating in the rape of a citizen of the Republic of Kenya. In this rape, you joined other state functionaries as an accessory. These accessories, equally guilty as you, are one, then Chief Magistrate Wilbroda Juma, guilty as in the case of Justice Wakiaga. Deputy Registrar Mabilianga, guilty as in these other two. For the Bureau Chief in the Office of the Director of Public Prosecutions, Mr. Kaigai, you don't merit consideration. You are lower than low. Ladies and gentlemen, coming up are the Kinyanjui series of videos. In these videos, we discuss the place Mr. David Bura Kinyanjui has been allocated in our judiciary. I'll be highlighting quite plainly the place that a number of judges have allocated Mr. Kinyanjui in their courts. I'll follow a different approach because this time I'll start from the end. I'll start with a ruling by Justice Dora Chepkwony in a technical application in which the judge is asked to find Mr. Kinyanjui and the law firm of Mazzayo, Mrima and Jadi as not having conformed with the law in the representation of Mwalimu National Savings and Credit Cooperative Society. Now, we'll be discussing the place that Justice Joki Mwangi, Justice Mary Kasango, and now Justice Asenath Ogeri allocate to Mr. Kinyanjui and the law firm of Mazzayo, Burima, and Jadi, and their equally doje clients, Mwalimu National Savings and Credit Cooperative Society Limited. You might notice here that the judges I mentioned in this case incidentally happen to be female. They did not make their decisions as collectively. Each made their decision on their own. But sorry to say it because this is a bit politically not so correct, but my experience is that the female person is not really called to jurisprudence. There could be exceptions. Sorry for saying this, but I have this feeling, and you also have the same feeling when you are through with me, that the female person is not called to jurisprudence. And that feeling is supported by the Islamic understanding of the female witness, that For 2 male witnesses, you require 4 female witnesses. And remember, by the way, at my stage in life, I had a dear mother since she's passed on since. I'm married, I have a daughter, I have sisters, and I respect them very much. But I know I certainly what they are not called for. And if if these lady justices they would accept their limitations, then they would come up with a rule of the thumb on how to negotiate something for which they are not called for. So, ladies and gentlemen, it's going to be hot up ahead. If you thought that the Wakiaga Saga was hot, no, 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 no. This is going to be blue hot. Stand by for this. Thank you very much.